watching us on the internet during the live streaming. And we're going to talk a lot about very brave people here during this panel. And let me tell you that we appreciate also your bravery of being here so early on a Saturday morning. So thanks everybody for being here. I'm just going to spend some minutes to present what we are going to do here this morning, and also ourselves, of course. I am Filippo Di Salvo. I'm a researcher in communication and journalism at Università della Svizzera Italiana, which is the Italian-speaking part of Switzerland. And there I work for a project called the European Journalism Observatory, and I'm doing research on digital whistleblowing and practices to do that on the internet in a safely way. And beside that, I'm also a journalist for the Italian Wired magazine. And today I'm very happy to be here seated among people I like and respect so much. So I'm gonna just introduce them briefly. On my left, we have Alex O'Brien. She's an American investigative journalist. She has been publishing several important news outlets such as Slate, The Guardian, Salon, Daily Beast, etc. She's probably the journalist who has been more involved in the Manning case, and her work on the trial and the pre-trial phase of that situation has been really impressive. And we also have Annie Machon here on my right. She's a former MI5 officer and turned whistleblower, and she helped whistleblowing about misconduct which was done in the English intelligence community. She's also author of a book called Spies, Lies and Whistleblowers, MI5 and the David Schuyler Affair. She has then worked for the Courage Foundation, and she is now the European Director of Law Enforcement Against Prohibition and co-founder of Code Red, a new project you will be hearing more about today at 1 p.m. in Sala Priori here at Hotel Brufani. And then we have Ben Wizner on the right. He's the director of ACLU Speech, Privacy and Technology Project, which is dedicated to protecting and expanding the First Amendment, freedom of expression and right to privacy. And he is also Edward Snowden's lawyer. And here on my left, I have instead Antonella Napolitano. She is the communication manager for the Italian Coalition for Civil Liberties and Rights, which is also the organization that made these panels and others here at the festival happen. She's also the Europe editor for Personal Democracy Media and tech president. So what we are going to do this morning here is talk about whistleblowing, and in particular about Chelsea Manning, who I'm quite sure you know about. She's the whistleblower who gave to WikiLeaks a vast amount of documents and information which were published since 2010. And I just mentioned 2010 because 2015, sorry, it's marking the 5th anniversary of several things. In particular, on April 5th of 2010, the video Collateral Murder was published by WikiLeaks, and it was a video footage of an American helicopter shooting some people in Iraq, and that was published almost exactly 5 years ago, and that was the beginning of the major WikiLeaks publication. And on May 27th, 2010, Chelsea Manning was arrested, and she has been in prison since that day. And this is sort of the reason why we are talking again about whistleblowing here. Yesterday night we had the pleasure and the honor of having here Edward Snowden speaking at the International Journalism Festival in Perugia, and of course we will be back on that. But what's really important here is to discuss what Chelsea Manning and other whistleblowers are facing for having been journalistic sources. Chelsea Manning has been condemned for 35 years sentence and is now in jail. And a very important point of her sentence was the use of the Espionage Act, which has been addressed a few times against whistleblowers under the Obama administration, and this is the fate that also other whistleblowers are facing. And I'm just going to mention a few names. John Kiriakou, for instance, which is the man who used the word waterboarding first, has spent 30 months in prison and has been released recently for having been a whistleblower. Jeffrey Sterling has also been convicted, and his sentence is coming soon in April. And he was also a whistleblower and a journalistic source, and he was under trial for probably having given information to James Risen, the New York Times reporter, who used some information Sterling gave him in his book, State of Terror. And of course, it's also the situation of Edward Snowden, who has been charged with 3 felonies, 2 of which are under the Espionage Act. And this is really scary if you think how the definition of espionage can be applied against journalistic sources, journalists, and journalism at large. And of course, these cases are some of the most important of recent times, but whistleblowing, of course, is not something that was invented 5 years ago. Whistleblowers have been supplying information to the press since journalism exists, and we can mention the case of Daniel Ellsberg in the 70s, just to mention for probably the most famous one, together with the Watergate. So here we will try also to make sense of whistleblowing, discuss what it is and what's its important for our society and for journalism in general. And we're going to proceed this way. We will have now individual speeches for about 10 minutes each with our panelists, and then we will kick in with the discussion among us, and we will still have 15 minutes for questions from the audience. So since we are in a way starting from Chelsea Manning, I will leave the microphone to Alexa, which will talk us about the Manning case and the trial she has been facing and all that. So Alexa, the floor is yours.
Thank you for having me today, and I'm very grateful to have the opportunity to talk to you about a very important case, and that's the case of Chelsea Manning. Chelsea Manning is a young trans U.S. Army whistleblower convicted to 35 years in prison in the summer of 2013 for disclosing documents to a media organization. Many of the victims of the crimes and wrongdoing revealed in the documents that she disclosed are not members of a Western electorate. Her revelations don't affect the bottom lines of Silicon Valley tech firms. She was convicted under the espionage and the espionage language encapsulated in the Computer Fraud and Abuse Act for portions of 247 documents. So when we talk about Manning, we need to talk about, in the Espionage Act, we need to talk about these 247 documents. During the court-martial, the public did not know the identity of most of the 247 documents charged against her that she was convicted for disclosing. I reveal for the first time today that CENTCOM declassified 44 of the 116 cables that Manning was charged and convicted with disclosing. Portions of 44, sorry. And despite a defense request to declassify those documents for her trial, the legal status of the documents remaining classified despite their wide dissemination on the internet prevented her lawyers from citing them openly in court and her defense witnesses had to have security clearances to testify about the documents. The fact that defense witnesses had to have security clearances to testify about documents that were widely disseminated on the internet and that they knew about may ultimately become part of her appeal, which is imminent. It's expected to be filed in the next couple of months. And that might become part of the challenge that her appeal brings to the Espionage Act. In fact, it's the only solid and real challenge to the Espionage Act that we have actually going. Over 500,000 US government employees and contractors had access to the documents that Manning disclosed. One of the documents that put Manning away in prison for 35 years was entitled Kingston, Jamaica Malaria Update. Another document that put Manning away in prison was a diplomatic cable concerning an inquiry regarding the use of Iceland as a basically transit point for extraordinary rendition. 5 years later, no one's been harmed. Her releases revealed or confirmed mass civilian casualties by US forces in Afghanistan, US complicity in the torture of detainees by Iraqi forces, the existence of more children than we knew at Guantanamo Bay prison camp, and the training and death squads in Bangladesh by the UK, and so much more. But I don't think that her story or its challenge is new. The good person or the good soldier on trial is a central tenet of Western philosophy and literature. And free thought is always dangerous to the status quo. Encryption is really merely the exoteric form of esotericism practiced by philosophers of old. She reminds me, and her trial reminds me of how powerful witnessing is and how difficult wisdom can be for us collectively. It can be very difficult to package Manning because her path resists our commoditized politics, philosophy, and assumptions. In some ways, and you have to, forgive me, but I'm gonna say this, her impact goes beyond the traditional mechanics of organized politics. Manning challenges, as a person and as a political figure, challenges the anima and animus archetype of our philosophical eros and thumos discussed by Plato. She strikes much deeper and casts a net much wider. She created and continues to create a new kind of order, and that is her political statesmanship. The only thing I ever worried about covering Manning's trial was whether or not I had enough patience, fortitude, and courage to do what needed to be done in order to serve the story. And I still worry about that, because when you work 18 hours a day and you don't spend any time with your family and friends, you lose patience. And you lose the ability to communicate clearly. And I've experienced that. And when you find yourself becoming the repository, unofficially or otherwise, of the court record, and we really did deserve whether, in the federal system, you have a right to the documents. In Manning's court-martial, because it was under a military jurisdiction, the prosecution and the judge basically owned the court record, and they didn't grant us that court record. And so it ended up creating an information vacuum that allowed the military to manage the message coming out of her court-martial. So when you become the unofficial repository of that, it can be incredibly stressful. But my problems are like nothing compared to Manning's. I'm just saying that this particular trial sort of demanded more, I think, than I actually thought I actually had. And it continues to. But I think it also requires more from us as a people, as a society, as a collective, so to speak, engaged in conversation. Because fundamentally, it's how we treat Manning, how we cover her story, is not a reflection on her, it's a reflection on us. Much like Plato's Apology is a reflection on Athens. It's not a reflection on Socrates, so to speak. Manning trusted us with her life when she appealed to the public conscience, which is the higher law, even higher than her own conscience. And in that way, she created her own hope. Whistleblowers at the time, especially in the US military intelligence, have no legal means of disclosing classified information about how the state illegally or wrongfully employs violence. And when they do, those whistleblowers, like Manning, face the severest retaliation by the state's own hands. But Manning continues to serve us because she went to trial. And I'll say this because, you know, the title of this particular talk is Heroes and Traitors, and, we've heard that sort of brought about and brought up by a lot of journalists and media organizations. But she continues to serve us. You know, while Snowden might complain about the unfairness of the Espionage Act, and it is unfair because it excludes intent, intent becomes not relevant at trial. It doesn't matter whether Manning intended or didn't intend to hurt the United States. She can still be charged and convicted of the Espionage Act. And all that evidence isn't allowed at her trial, and it wouldn't be allowed at Snowden's trial. It's a strict liability statute. The fact of the matter is Manning went to trial, and she was convicted to 35 years in prison. And her appeal, again, she continues to serve us, will challenge the Espionage Act. The dump narrative regarding Manning is also a red herring. As I said before, Manning was convicted of disclosing 247 documents under the Espionage Act. So if you use that paradigm, the good versus bad whistleblower that has been covered by people like Rancid Tarzi on Twitter and the like, it doesn't stand up under scrutiny. I don't know how many documents Snowden has been charged with because he hasn't gone to trial and there's no bill of particulars. But when it comes to, making an educated guess, I would posit that he would be charged with more than 247 documents under the Espionage Act at a higher classification than Manning, because Manning leaked low-level battlefield reports and low-level reporting from US government agencies. And Snowden's leaks cover more than simply mass surveillance. So if you're going to use that paradigm, Manning would appear to be the responsible whistleblower, and Snowden appears to have dumped. So I want to say this. I think Manning and Snowden's leaks are proportional to the age that they are a part of. They are children of the internet age. They are children of Facebook and Twitter. And I don't think that that particular paradigm is actually a useful one. I don't think that, it's not one that I ascribe to personally. I want to just sort of talk to you also really quickly as I end about fiction and journalism. It's funny because at the height of Manning's trial, there were 3 Hollywood films about this particular character in this trial and no official transcripts. So that will kind of tell you what my opinion of the fiction that came out. And I think fiction plays an important role in political discussion just as much as facts do. But journalism is said to be about publishing facts and making reasoned arguments. And yet much of what passes for news, quite frankly, is gossip mongering and bad fiction. The voice that I heard at the trial of Chelsea Manning was the voice of the greatest modern war story ever told. It was the voice of all quiet on the Western Front. I am young. I am 20 years old, yet I know nothing of life but despair, death, fear, and fatuous superficiality cast over an abyss of sorrow. I see how peoples are set against one another and in silence unknowingly, foolishly, obediently, innocently slay one another. It is the voice of a thin red line. Maybe all men got one big soul, everyone's a part of it, all faces are the same man. What difference do you think you can make, one man in all this madness? It is the voice of Catch-22. It was miraculous. It was almost no trick at all, he saw, to turn vice into virtue and slander into truth, impotence into abstinence, arrogance into humility, plunder into philanthropy, thievery into honor, blasphemy into wisdom, brutality into patriotism, and sadism into justice. Anybody could do it. It required no brains at all. It merely required no character. And to pay homage to one of the greatest American poems ever written by Ginsberg, I would say that Manning's sacrifice continues to put the rubber to the road. Her appeal, like I said, will be the only solid challenge of the Espionage Act that we have going. And so in that way, she continues to put her queer shoulder to the wheel. Thanks.
Thank you very much, Alexa, and we'll now move to Annie to discuss whistleblowing, what it is, why it's so important, especially in the context we are living of massive surveillance on the internet and extremely national security and overclassification and all that. So the floor is yours.
Thank you very much, and thank you to the organisers for inviting me to speak. I'm very heartened to see the continuing level of interest in the issue of whistleblowing that has really hit the journalist community over the last few years, particularly since the Manning and Snowden cases. I want to start by saying one of the groups that I work with is called the Sam Adams Associates, which is a rather arcane name for a group of very eminent intelligence whistleblowers who have been operating since the 1970s. We comprise people such as Daniel Ellsberg, Thomas Drake of the NSA, Ray McGovern from the CIA, Colleen Rowley from the FBI, Catherine Gunn, GCHQ, and myself from MI6, as well as many other people emerging as whistleblowers out of the diplomatic corps of the US and the UK, and also people coming out of the military. And I raise this because we give an award annually, and last year we gave this award for integrity in intelligence to Chelsea Manning. And I want to honour her for her bravery and her sacrifice and what she has given to the world as evidence of war crimes committed by the USA. I also want to honour Edward Snowden for his courage in speaking out even as Chelsea was going on trial and knowing that he would probably face at least the same kind of penalties if he were caught for what he blew the whistle on. The degree of courage to go on the run and to do that and expose so many horrendous facts for all the world's citizens, for the benefit of us all, about how we're being surveyed, is an immense sacrifice, an immense contribution. And I think those two very brave young people are probably the two most significant whistleblowers to have emerged in modern history. So I just want to say thank you to you both. Just to reprise slightly, I too was involved in whistleblowing, but this was back in the 1990s. So we're talking the analog era then, which had its pluses and its minuses, because at that time it was much easier to evade capture because there wasn't this endemic surveillance out on the streets and of our communications. However, it also made it much more difficult to disseminate as broadly as possible the evidence of the crimes that I and my former partner, a man called David Shaler, wished to disclose to the world. Just to recap the case very, very briefly, we both worked as British intelligence officers for the UK Domestic Security Service, MI5, and we were there for 6 years, 3 postings each, working in the political, the Irish terrorism and international terrorism branches. And during that very short time there, we saw so many things going wrong that we felt obliged to resign and to go public about them and blow the whistle. So these ranged from files on government ministers, illegal telephone taps, some might say no change there, to innocent people being put in prison, to bombs that should and could have been prevented, but MI5 allowed to go ahead on British streets, and they killed innocent people, and up to and including innocent people going to prison and an illegal assassination attempt against Colonel Gaddafi of Libya in 1996, which was funded by British intelligence. Now, crucially, this was illegal, and obviously it went wrong, because Colonel Gaddafi survived to be assassinated by the very same groups back in 2011. So we hadn't signed up to the intelligence agencies to be complicit in what was effectively state-sponsored terrorism, which is why we resigned and decided to go public. Now, in those days, it was much more difficult. We only had a very baby concept of the internet. There were no WikiLeaks to go to. We had to rely on the old mainstream media, which meant, in our case, David taking documents and handing them over to a newspaper in the UK. That was the proof he had of all these crimes he wanted to disclose. Unfortunately, of course, then, the government could insist and issue production orders to that newspaper to hand that proof back over to them, and you lose it. So that was very frustrating. But in our case, we ended up going on the run, literally, for a month around Europe. We had to live in hiding for a year in France. David went to prison twice, first of all in 1998, when the British failed to extradite him from France to stand trial for a breach of the Official Secrets Act in the UK. And then in 2000, after we'd lived more openly in exile in Paris, he returned to the UK knowing he would have to face trial, but wanting his day in court to have this evidence read into the public record. And of course, he was convicted under the Official Secrets Act, because again, there is no defense. You can't argue that there is a public interest. You are automatically the criminal if you expose the crimes of the spies. So it's a very high price to pay. And I think probably we are the only two intelligence officers, other than Edward Snowden, who actually went preemptively on the run before the story broke. So I think it's a very different landscape, though, now, because there are other options in terms of how to publish your information if you're a whistleblower. We can go to organizations, or you could go to organizations such as WikiLeaks, and get a wide dissemination of the information. It also, of course, meant that if you passed the documents anonymously, then the documents were cached, they were safe, they could not be handed back to the authorities, the information could not be buried. So I think that's a very, very important advance in how whistleblowers can operate in this modern world. And I'm very well aware there are many other new platforms, including global leaks, which are available for whistleblowers to use. And I think this is a very important step forward because it allows them the potential to remain anonymous as they pass the information over. In the old days when you went to the mainstream press, the pressure was on you to be named. You lost your anonymity and you were automatically therefore facing prosecution. Now, for example, you have cases like Manning who could leak the information to WikiLeaks, and then we, the world's people, all had a chance to read it. So that's a very strong step forward. Of course, now we've seen the pushback for WikiLeaks as well, and the pushback of surveillance, which Snowden has exposed, in order to prevent whistleblowers being able to get access to these sorts of platforms. We know, ironically, from a document that was leaked to WikiLeaks in 2010, that the American government, and also we know now as well the UK government and spy agencies, consider whistleblowers to be the insider threat. And they are investigated just as stringently as terrorists would be. They are seen as that degree of threat to the integrity of the intelligence organizations. So there is a pushback, and I think journalists still have a very strong role to play in this. One is we need more campaigning journalists. For example, I know Glenn Greenwald has been excoriated for being a campaigning journalist, for not being as objective as he should be in his reporting of Edward Snowden's disclosures. Well, I'm sorry, you need a journalist with fire in their belly. You need someone who will fight for you. You need someone who will contextualize what you are saying and make sure that your name stays in the public awareness. Otherwise, what you do, you just end up disappearing and languishing in prison for the rest of your life. So that's a very important role for journalists, to ensure that the issues stay in the public mind and can be properly investigated. And I think now we've never had greater need as well. Just to finish, we've never had greater need of more whistleblowers coming out. As Snowden disclosed, we are facing the biggest global surveillance panopticon that we have ever been threatened by. You know, this goes way beyond George Orwell's 1984 fantasies. I mean, this is a modern-day dystopia. And there will be more people coming out. And we need to be able to protect them. We need to give them secure channels, using all the various tools at our disposal and at the hackers' disposal to protect their early communications and to ensure that they can remain at liberty to argue their case. In this weird world of ours, with illegal wars and with drone strikes and torture programs and all the other horrors, we've never had greater need of high-end intelligence whistleblowers. And it's sad, I'm sad to say, I think this shows a failure, a systemic failure of the oversight provisions, the accountability provisions, and even the provisions for natural justice for great swathes of the planet, that we have to rely on whistleblowers turning their lives inside out and upside down, facing their lives in prison to get that information to us. So I would say that they are the regulators of last resort in the modern world, and we need to honor them and protect them. Thank you.
Thank you, Annie. And I guess what you said about protection of whistleblowers is the perfect lead to Ben, which will talk about this topic from the perspective of being the lawyer of a guy called Edward Snowden.
Thanks. I will try to keep my remarks brief so that we can get to the discussion portion. But yes, I will begin where Annie finished. imagine a world without unauthorized disclosures to the press. And let's look at just the recent history of the world, and particular wrongdoing by the American government. Without unauthorized disclosures to the press, the world would not know the details of how the case for war in Iraq was based on exaggerations and lies. We wouldn't know that American soldiers tortured and sexually humiliated prisoners in the Abu Ghraib prison in Iraq. We wouldn't have known that the CIA set up a rendition program in which it kidnapped foreign citizens off the streets, chained them to the floors of planes, flew them to secret prisons, and subjected them to brutal torture techniques. We wouldn't have known the details of that torture program, that prisoners were chained to the wall and ceiling, that they were beaten, that they were kept awake, that they were drowned nearly to the point of death in waterboarding. We wouldn't have known the details of a US drone program in which people are targeted for death far from any active battlefield. All of this information was not just classified by the US government. It was classified at the highest top secret level. And the goal of the US government was that the US public and the world public would never know the details of any of this. And I think it's almost impossible to make the case that our free societies would be stronger if the public didn't have access to this information that we only have because people in government, in cooperation with courageous investigative journalism, broke the rules that the government set to bring the public into the conversation. One question that we have heard over and over again in the Manning and the Snowden affairs is, who decides? Why should we allow these young people to essentially override the decisions of elected and appointed officials who are the only ones who have democratic legitimacy to make the difficult decisions of what should be public and what should be kept secret? But I hope that those examples, and we could go from 5 examples to 50 on this panel with no difficulty, will persuade you that the answer to the question, who decides, cannot be the government. It cannot be that we entrust to government officials the right to tell the public what information we can use in order to judge them and hold them accountable. Now, there have been efforts in free societies to create mechanisms other than whistleblowing that would provide oversight over intelligence programs. And I think almost across the board, those official oversight mechanisms have failed. In the Snowden case, for example, we've seen the footage over and over again of the leaders of the US intelligence community testifying under oath in the US Congress and blatantly lying about the extent of the US surveillance program. Now, that wasn't just a failure of those officials. It was a failure of the Congress, because the members of Congress who were asking those questions and hearing those lies knew that the answers were false, and yet honored their secrecy obligations over their oath to the Constitution and their responsibility to the public. We saw that challenges by legal organizations to surveillance programs, torture programs, were not even considered by American courts. They were thrown out on grounds of secrecy and national security. And so instead of playing their constitutional role and determining whether the challenge programs were legal or illegal, the courts told us to go home. And just a few months before the Snowden revelations, the United States Supreme Court turned away a challenge by my organization to NSA surveillance using the following logic. They said that we had no right to be in court because we had no evidence that our plaintiffs had been subjected to surveillance, but that we could not obtain evidence about whether our plaintiffs were subjected to surveillance because that was a state secret. And therefore, neither we nor anyone else could bring a legal challenge to these programs. And it was in that environment where the entities that had been established to conduct oversight, the Congress and the courts, had failed across the board and so dramatically that someone like Edward Snowden, working with journalists, stepped in and said, we have to find some way for the public to be brought into this conversation. And I think one of the ironies of these cases is that sometimes it requires a dramatic act of law-breaking in order to revitalize those mechanisms of democratic oversight that otherwise fail. So now we actually are seeing courts fulfill their constitutional role and consider the legality of these programs. Now we are seeing for the first time, really since the 1970s, a reasonable debate among legislators about whether new controls have to be placed on the surveillance system. So just a few words about the legal regime that faces people who make this decision to inform the public. And you've heard a little bit about it already. The Espionage Act and other laws that are used against whistleblowers and leakers is extremely crude. It essentially equates providing information to the press in the public interest and selling secrets to foreign enemies. But in fact, the government has gone further, and in a recent legal filing, the US Department of Justice argued that giving information to the press was actually worse than selling it to a foreign enemy, because if you sold it to a foreign enemy, only one enemy might get it, but if you publish it in the press, everyone gets to see it. And that's quite an extraordinary statement, and it reflects the position of the US government that it is worth depriving the public in a democracy of information if that's the cost of making sure that no one else in the world will see it. But in fact, more often than not, the intended public that is not supposed to see it is the public of one's own government and not any foreign enemy. And so we need to think about what a more reasonable system would be. If we recognize that whistleblowing in the public interest is a vital part of democratic oversight, how would we reform a system to take account of that? So as you've heard, as Alexa said, under the Espionage Act, there essentially is no defense of public interest. It is a strict liability offense, as she said. What that means is there's no ability for the person on trial to explain his or her motivations. There's no ability for that person to make a case for why the public benefited rather than was harmed by the disclosures. There's no requirement that the government make the case that the information was properly classified in the first place. It's not relevant if the information disclosed showed that the government had actually committed crimes. None of this information is relevant at all in a trial under the Espionage Act. Daniel Ellsberg, who was the first person ever prosecuted in the United States under the Espionage Act for leaks to the press, tells a story about his own trial in the early 1970s. He was on the stand. He had rehearsed with his lawyer how he was going to explain why he did what he did. And at that moment in the trial, his lawyer said, "Mr. Ellsberg, why did you think the public needed to read the secret history of the Vietnam War?" And the prosecution said, "Objection." And the judge said, "Sustained," meaning that information is not relevant. The only thing that's relevant is that you had access to national defense information, you turned it over to someone who had no authorization to receive it, and that's it. There really is no defense. Now, you can say that Daniel Ellsberg was lucky, although lucky is a funny way of describing what happened to him. The government's conduct against him was so outrageous. They broke into his psychiatrist's office to steal the private notes. The president offered the trial judge the job of FBI director during the trial. This conduct was so outrageous that the judge threw out the case on grounds of outrageous government conduct, which is essentially unprecedented in the United States. And so Ellsberg's trial never ended. But you can be sure how it would have ended. He would have been convicted, and he would have been sentenced to a long term in prison. So we need to come up with a more humane and balanced way of evaluating leaks to the press in the public interest. We need to recognize that not all leaks are the same. Not even all leaks are whistleblowing. Most leaks that take place in the United States are not whistleblowing at all. They involve high-level public officials leaking information to favor journalists in order to promote certain narratives, in order to aggrandize their own departments. So we need a system that is able to make these kinds of distinctions and not treat all leaks the same. And we need a system that doesn't selectively go after younger, less experienced, less protected people while giving a free pass to people like David Petraeus, who was the director of the CIA and a high-level general in the military. And this is important not only so that we can create more just outcomes for people like Chelsea Manning, who risked and gave the best years of her life to inform the public, but it's actually vitally important for the public itself to have this information in order to preserve the democratic system. Thanks.
Thank you very much, Ben. And I will now move to Antonella, which is going to talk us about the situation of whistleblowing in Italy and the culture of whistleblowing in Italy, if we have one.
Short answer, no. Well, first of all, good morning. I'm very happy to be here in such a great company. And first of all, I want to say a couple words about CILD, the Italian Coalition for Civil Rights and Freedoms, Coalizione Italiana Libertà e Diritti Civili. We are a coalition of more than 30 organizations working on human rights, civil liberties, ranging from these kind of issues like privacy, freedom of expression, to migration, LGBT rights, Roma rights, prison condition. And we are a very young organization in Italy. We were born just last year, and our objective is to create a bigger and more impactful network of organization. It's based on the idea that if we get together, we can have more impact, but also on the idea that rights and liberties are not separated one from the other. They're interconnected, and they need to be faced and analyzed and advocated for in this way. So we're very happy to be here at the festival to organize yesterday's panel with Edward Snowden, today's panel, the presentation of Code Red to today one, and other panels in the afternoon. And I'm happy to be here to talk about whistleblowing because, well, as Philip said, is there a culture for whistleblowing in Italy? No, actually, there is not even a word, an Italian word for whistleblowing, which makes it even more difficult to talk about this. And a few days ago, I was talking to someone about this, and my thought was, we don't know the word, and actually newspapers like media are talking about Manning, Snowden, and whistleblowers with different kind of words, even if they don't try to characterize them as, heroes or traitors, but they probably gonna call them spies or something like deep throat, because we also all demands president. They try to find some point to try to understand, because we don't have that kind of culture, and probably just because we didn't have that kind of cases. But the point is that what if you don't talk about whistleblowing, but you analyze the meaning? Like if you think about blowing the whistle, you would probably think more about, shouting danger if there is, if there's a fire, you blow the whistle. If there is trouble, if there are problems, so you are warning other people. And still, we haven't found a word, but there are whistleblowers in Italy. At the moment, whistleblowers in Italy are not people like Manning or Snowden. They're not showing the word state secret, but there are people who are trying to denounce corruption in the public administration. Corruption, and we hear about corruption like every single day in the media, but we struggle to make this kind of connection. It's like it's happening to someone else. It's happening out there. It doesn't relate to us. Well, first of all, of course, it relates to us. Of course, it's creating damage to our society. But there has to be said, there are people who are trying to denounce corruption, and they face negative consequences, only negative consequences, because they don't have protection. There is no law to protect whistleblowers, to protect people who like civil servants, public officials, who want to denounce mismanagement or corruption inside the government and the public administration. And so, more often than not, they are isolated, they are harassed, they are threatened, and in some cases, when corruption is related to organized crime, they even face like more serious consequences. There is, and it's very likely that people doesn't know, there is a bill, there is a proposal of law in the parliament. I mean, it's still in the Justice Commission. It is like 18 months, and it's a proposal to protect whistleblowers, to give them protection if they want to denounce, well, not only corruption in the public administration, but also on big enterprises. It's the kind of things that we hear about every day. The Expo, Mafia Capitale, like all the biggest scandal, and we have once a month, we have a bigger one. As much as we talk, as much as the government talks about corruption, fighting corruption, and there are several ways, this is not the only one, but this bill is still in the Justice Committee. It hasn't progressed one step almost since the first time. And another point that I'd like to make, so this is whistleblowing is not just this, which is very important, and which it can happen to Italy too. We don't have cases yet. But also it's something that kind of intention, denouncing corruption and actions that are not lawful, even if they're legal, or the reverse. We should think that it's something that relates to us more than we think, and in our everyday life. When we hear about corruption is costing us 60 billion euros a year, we should think about this too. And another thing that I'd like to make is, well, Annie said, who decides? Ben, we all talked, Alexa, Ben, and Annie, we all talk, who decides? We talk about these people who decided to denounce that what the government was doing was not right. And it's, as a human rights organization, as an organization that thinks that these are human rights, that privacy is a human right, that privacy leads to a broader freedom of expression, deciding it's also being more informed. It's also knowing what are the consequences for us. It's also knowing that we have the right to know certain things in the government. And another thing that we have to say, in the United States, there is a law called Freedom of Information Act, FOIA, the acronym. In Italy, we don't have a Freedom of Information Act. We have an access to information law that dates back to 1990. So yeah, it's 25 years. It's a very restrictive one. You can only ask for information that relates directly to you. You cannot ask, there is a specific provision in the law that says that you cannot ask for documents to control, like to make the government accountable. it's something that civil society is trying to change and advocating for freedom of information and proposing a Freedom of Information Act. And there's going to be talks about this too at the festival later in the day. So, and one of the points is that we have a 25 years law about the right to know, and we didn't use like the small like amount of power that we were given. And journalists who have a broader right in this respect in Italy, they don't use it that a lot too. They prefer to only rely on relation to politics. So, and this is the final point. So maybe we won't be whistleblowers, maybe we won't be in the position to denounce corruption, mismanagement, state secrets, the government acting in the wrong way, but still we get to not decide probably, but to know more, to exercise our right to know, to be more informed, and to be part of a decision. Probably, we don't know, I don't like to talk about solution because we don't know, but we can be part of a decision. We can be more active and aware citizens. Thank you.
Thank you very much. Grazie mille, Antonella. We will now. I have some questions for all of you, and we will have still 20 minutes at the end for opening the mic to the public. And I would like to start from you, Alexa. And you said that the Manning trial was done in a de facto secrecy, and the press had very strong difficulties in getting access to what was going on. And do you think that the absence of the press to the trial and the very low interest that journalism has spent for Manning, for the Manning situation, is also a sign that journalism is not that interested in following the consequences of whistleblowers as it is when whistleblowers are supplying information? And for instance, Project Censored in 2014 mentioned the Manning trial as the most censored news of that year. So how would you comment on that?
Well, I think it's a good question. I think it's you have to unpack it a bit. Of course, the type of leak also determines whether or not the journalism as a whole is interested in covering a story. I'll compare the two major leaks we have now. You know, Manning leaked military reporting and diplomatic reporting as part of U.S. foreign policy. As I said early on, you know, the victims, so to speak, of her releases are not members of a Western electorate for the most part. The releases dealt with mass civilian casualties. In fact, she leaked 14 documents related to, they were Petraeus briefings. Ben had mentioned Petraeus being forgiven, so to speak, for his disclosures compared to whistleblowers like Manning. Well, 14 of the documents that Manning leaked pertain to mass civilian casualties by U.S. forces in Afghanistan. So when you look at the Snowden releases and you talk about impact, you have to also recognize that they affect political economy of the United States. Information and entertainment. You know, the United States dominates every sector in the information, the United States has a surplus balance of trade with every nation in the world when it comes to media and entertainment. And so also you have a press that's already set up to actually report on technology and information and these kinds of things. And so institutionally there is a different response. I think it's unfair to criticize journalists just as a talking point, because what I saw at the Manning trial was, yes, I saw lazy journalists. I saw the CNN guy who happens to be a nice guy, but he slept through the Manning trial, okay? I like him personally, but he was actually snoring in front of me. And he'd wake up and say, what's the title, traitor? Like, and then start typing into his, so we had like a love-hate relationship. But there are also journalists at major papers of record who wanted to cover the trial, but the military district of Washington made it incredibly difficult for them to organize themselves with their editors, with the kinds of things that institutional press needs. They need to tell their editor, I'm going to Fort Meade, where the trial's held on Tuesday, September, whatever, and this is what it's going to be about. So they need access to the court record. If you're going to cover a trial of this import, of this complexity, this is the longest record known in military law. It is 40,000 pages long, and it encapsulates very complicated and obscure legal arguments about aiding the enemy, which wasn't charged in this fashion ever, but in relation to leaking to a media and therefore aiding the enemy, the case law was like Civil War 1863 precedent. So if you don't have access to a public record, even if you are the most gung-ho, passionate journalist, and you have a regular job, you just can't cover this trial the way that it needs to be covered. Let's say you have a family and you're working at, a paper in San Francisco. How are you going to cover this trial? You can't. So there are complicating factors, but I do think that the journalists I saw wanted to cover the trial. The institutional inertia of the military district of Washington and their own editors oftentimes impeded them from doing it in the way that they wanted to.
And Annie, I think that what Alexa just mentioned about the content of the leaks also determines the way that whistleblowing cases are also then framed and dealt with by the press. And in your case, and in the case of Snowden, it was national security. So you're now about to launch an initiative which is anti-surveillance. And what do you think will be the end game of this? Julian Assange once said that national security is a new religion to governments, and they have this sort of mystical approach to national security. Do you think the whistleblowers will have the power and will be sort of the weapons that the public opinion have to break into this situation?
Well, it's a very rich question, that. Certainly coming from the British perspective, we have an obsession nationally with spies, all things intelligence. And I think part of this comes from the wonderful PR that is the James Bond franchise, as well as John le Carré and all those sort of spy writers. So that is a very powerful sort of myth. And we in Britain liked, and I think also over the last few years in America, like to think that our spies are the good guys, and this is only beginning now to corrode because of the more recent whistleblowers. So we like to think that we're always on the side of good, they will never abuse the laws, they will protect us. I think what we're seeing now with increasing number of whistleblowers coming out is this degree of interest is still there, this obsession with spies and intelligence and national security. But actually, there's a much more critical approach to it. So, for example, in the Shaler case back in the 1990s, there was this huge interest, and despite the government's best interests at trying to control the media outlets in terms of what information was put out there, by briefing very heavily against the whistleblower, by threatening newspapers with prosecution, by imposing voluntary censorship, which is something called the D notice in the UK, a lot of journalists were still empowered enough to bring out that sort of information and to report it. It was only when it came to the trial itself, and this resonates very much with what Alexa was saying about Manning's trial, that the government actually put something which is known as a super injunction in place for the 6 weeks of David's trial, which meant the journalists were allowed into the courtroom, but they weren't allowed to report certain issues, and they weren't even allowed to report the fact they were banned from reporting certain issues. And one of those key issues, of course, was the Gaddafi assassination plot, which had been all over the national media and international media for the preceding 5 years. But in the courtroom, over those 6 weeks, nobody was allowed to mention it in case it made the jury more favourably inclined towards the whistleblower, the defendant. So this is a very wide range of ways they can control media coverage of these issues. And I think what we're looking at now is a pushback. So with Snowden, for example, the D notice in the UK was immediately put on the case. Most other media outlets have been very unfavourable. Only The Guardian has been continuously favourable around the Snowden disclosures. And for their pains, of course, they've had their hard drives smashed up, and the editor has risked prosecution. So, it's getting more difficult. I think there's an increasingly sophisticated pushback against the media, against increasingly sophisticated whistleblowers, and it's finding the channels to protect them, both through the media, old and new, including WikiLeaks, Global Leaks, things like that. But also, I think we do need to reform the laws. I've been saying for 2 decades now, we need an adequate and powerful channel for potential whistleblowers to go to, where they can give their evidence of wrongdoing in the full confidence that those disclosures will be properly investigated and any criminals within the intelligence agencies properly prosecuted and punished, and that the intelligence agencies can learn from those mistakes and then reform themselves to do their jobs better. I mean, in my view, that would be a win-win situation. The services improve, we are better protected, and the whistleblowers don't turn their lives inside out and go to prison. So that would be one channel. Unfortunately, in the UK, I think we're even worse than the US. We have no real oversight. We have 2 laws, not one. Official Secrets Act 1917, which is to counter traitors, and Official Secrets Act 1989, specifically to stop whistleblowers. And there is no public interest. There's no proper oversight in Parliament. The Intelligence and Security Committee, which is supposed to hold the spies to account, always defends them. And in fact, they leapt to the defence of the spies within a week of Snowden going public last year, saying, we know what the spies do, they're not breaking the law. And then, of course, all these further disclosures kept coming out, and of course, they were breaking the law. So we need a whole-scale reform, I think, of all this. And it's how to put the pressure effectively on these policymakers to make that change happen. Now, this is where Code Red comes in, just to wrap up. There are many, many wonderful initiatives. I mean, I speak at conferences all over Europe and North America on these sort of issues, on issues of the technology, the anti-surveillance, on the legal issues, on the media and the control of the media, and to whistleblowers, of course, as well. And some of these groups are beginning to come together and cross-pollinate to find realistic mechanisms to protect whistleblowers coming out in the future, and that is fantastic. But what is lacking, crucially, is their access to and experience of dealing with the policymakers to affect proper, meaningful legal change as well. So this is what Code Red is designed to do, partly. And many, many people, including Ben, around the world, very many eminent people, have already put their name to it. I'm working with Simon Davies, who is the founder of Privacy International and the Big Brother Awards, to get this Code Red organisation up and running, where we can bring all these stakeholder groups together to pull together an effective policy plan as well to properly regulate the intelligence agencies and protect whistleblowers. So that is one aspect, to bring together all these very effective groups and provide a clearinghouse so that they can all learn off each other, collaborate with each other, and have access to the people they need to have access to. So that's one aspect. And of course, the other is to carry on speaking out on behalf of the whistleblowers as well, especially those who the state has attempted to shut up by imprisoning and persecuting, where we need to be protecting them. Oh, sorry, one final point.
Yep.
We will be launching Code Red. If you want to hear more about it, Sala Priori, I think, at 1 o'clock. Simon and I will be discussing this. So do come along and spread the word if you can. Thank you.
Sure. And Ben, I would like to follow up on what you said. And I think that the most interesting part of your speech was about when you mentioned Ellsberg trial and how the court didn't recognize the relevance of the content of the Pentagon Papers, which is absolutely nonsensical. But looking back to what Snowden talked about yesterday night, and I think that the most relevant part of the Snowden revelation regards the way we discuss privacy as a civil liberty, as a fundamental human right, and how would you explain that? I mean, we usually hear that the Snowden revelation was nothing new. We knew already that we were being spied on, but in fact it wasn't like that. So, what's the most relevant part of what Snowden leaked to the press and to all of us?
Well, I think it's fair to say that much of what Snowden's revelations document supports information that was widely known, but provides the kind of documentary evidence that is sometimes necessary in order to generate a debate. So it's certainly people who had been following the issue of surveillance over the years understood that countries like the United States, the United Kingdom, and others had been building the capability to intercept, to collect, and to store all of our communications, our movements, and our associations. I do think that there were some genuine surprises in the Snowden revelations. I think even people who had been watching and challenging the law in the United States were shocked by the first document that showed that the NSA was collecting every day all of the telephone metadata records from every American and storing them for 5 years. This is something that we thought they wouldn't have the gall to do because it's so clearly illegal and unconstitutional, and that's the subject of litigation right now. I think the technology community, although they were aware of many NSA capabilities, were somewhat shocked to see how brazenly the NSA was attacking vulnerabilities rather than protecting them. And how much the NSA, which calls itself a security agency and complains about cybersecurity, was the leading actor in weakening cybersecurity around the world. And I think that you've seen a fairly dramatic response from the technology community to those kinds of revelations. But I do think that in part, the value of this disclosure was providing pieces of paper that could be put next to public statements by public officials that proved unequivocally that they had lied. And that's important because the currency of the national security state is trust. Trust us are the most common words that you hear from national security officials. Sure, we have these capabilities, but we follow the rules. Our motivations are correct. We're here to protect you from the terrorists. You have to trust what we say and what we do. We're not evil people. Well, that trust was properly demolished. And in fact, that trust is completely inappropriate in a democracy. The role of citizens in a democracy is to distrust government officials, not to trust them, because it's the tendency of government officials to protect their own power. And so that I think was part of the great value. It was you mentioned national security as a religion, quoting Julian. Yeah, we talk about the national security priesthood in the United States. And there is this feeling in that community that they are the elect, and that because they have access to information that the rest of us don't, they're uniquely qualified to make judgments. And they create legal doctrines to support that idea. When we bring challenges in court, they say, judges, you must defer to our expertise, which is exactly the opposite of what judges should be doing. They need to be pointing at their conflict of interest. If I sue the director of the CIA for torture, we shouldn't be deferring to his expertise. We should be saying that he is the least qualified person in the world to tell a court what evidence to look at and what evidence not to look at. And so, and again, we saw this with the photos from Abu Ghraib as well. In a sense, the public can hear a lot of words, but sometimes seeing the images is what's necessary in order to generate the debate and change the practices. And so certainly there's a lot of new information in the Snowden archive. Much of it is very difficult and very complex, and that's why it's taken the journalists a long time to report on it. But I think that in its totality, it has a different effect than in its particulars. In its totality, it's a record that can't be disputed. These are documents and pieces of paper and not just allegations. And so again, some of the other whistleblowers who you've heard referred to today, people like William Binney and Thomas Drake, had been making many of these same claims over the years based on their own firsthand knowledge of these programs, but because they didn't have the documentary evidence to give to journalists, it was very easy for the broader public to ignore the information and to marginalize them. I think those guys are looking a lot better and looking very prescient now, and it's nice to see that they're involved in a lot of the projects that you've heard described today.
Thank you, Ben. And Antonella, you mentioned a couple of things that are going on in Italy regarding the topics we are discussing here. A new law proposal for whistleblowing, a new proposal for a freedom of information access law. And when we were talking about this, I was the words of Snowden were coming back to my mind. And when he yesterday said, you know, the government won't never reform itself, and we need a movement from the people. We need civil resistance in order to promote that kind of reform. So, what's your view on this? Are you optimistic that something will change anytime soon, or we won't? And do you think that the role of, let's call it this way, the community, which is concerned about these issues, and I'm very happy that Annie mentioned Global X in this context. Do you think that that community can be a real impact on the decision-making process? Sorry about the question.
Well, first of all, I was happy too about the mention of Global X, because Global X is being used as software. It's the first open source software for this kind of to help whistleblowers to blow the whistle, you know, to denounce this kind of. And the point, and not many people know probably, that it's been developed by a group of Italian guys, developers from the Hermes Center for Technology and Human Rights. And well, first of all, I'm happy to say that the Hermes Center is joining the CILD, the Italian Coalition for Civil Rights and Freedom. So we are going to have, like, in the coalition, a group of people who are actively working on the technology side, but also on the, like, trying to work with policymakers. Another initiative that I should mention is the ALAC, the Anti-Corruption Alert, that it's being created by the Italian chapter of Transparency International to create a secure way for whistleblowers willing to denounce corruption episode, and the software has been developed by the Hermes Center, it's actually Global X. So, and it's pretty like funny, let's put it to quotes, that they've been using this software, they've been spreading like all over the world, the Balkans, Africa, Asia, and in Italy they're finding like so many difficulties because in Italy there is no knowledge, like even in the, like at the highest level, that you don't just, you know, send an email to denounce corruption. That puts you in danger, and that's something that has been said even by like public authorities. We're setting like a system to denounce corruption. Send us an email to, like, trust us. How can I trust you if you don't know how to protect me? So this is for the technology side that Snowden also mentioned yesterday. About the system reforming itself, I have to say I'm not optimistic in general. Well, especially because even like in the last 12, 18 months, there have been announces about, well, the current prime minister mentioned the need for a FOIA in his first speech at the Senate. Like 40 months later, we're still with no proposal from the government, who on the other side has been very active on other issues and on proposing legal action, like laws from the government. A proposal came from civil society. It's being presented to the parliament, to committees. There is a work, ongoing work. So the law will be changed. The proposal will be changed. We don't know if it's ever gonna come to the parliament for discussion. So it had to come from civil society. So I am optimistic about the fact that civil society is acting about this. Is also, and it's something, it's part of our job to make the people know and the organization know that a right to know is not just about state secret is not just about, it's not like a technology issue. The right to know is also a tool for journalists to denounce environment scandal that we all heard about. It's also, I mean, to denounce the inhuman condition, the terrible condition that immigrants face when they arrive in Italy. Refugees are left, they don't have protection, they don't have ways to, well, they're left like for months in this center for identification and exclusion. So the right to know, it's something that relates to so many issues, and civil society should know that it's a great tool for them. Whistleblowing, the bill, the Bussinarolo bill, it's in the committee. It's been there for a year and a half. I don't know if it will ever come to discussion. I have to say, just in general, very few bills come to discussion. The government is acting a lot. I really hope that these events, this kind of conversation, sort of pushes the government, but first of all the media, because also one of the part of the problem is that the media, journalists, haven't been pushing on this. And so who is going to hold the government accountable on this? On the promise to have a FOIA, on the promise to fight corruption, having a whistleblower protection law, it's one of the ways. So I am not optimistic if we're talking about the system reforming itself, but I'm kind of optimistic about civil society starting to act more, and of course it's our job to continue this effort and this struggle.
Thank you, Antonella, and we still have about 10 minutes for questions that I would like to open to the public. So we have here a microphone if someone wants, and one down there, so if someone wants to raise a question, just raise your hands. And for you guys, there are these headphones for the simultaneous translation if the question are posed in Italian. Yeah, sure.
I will speak in English. I'm not Italian, so I'm a French journalist, and so thank you for this very interesting panel. I wanted to ask you, as you mentioned, the price for being a whistleblower is very high now. What should be your practical advices for potential whistleblowers of today?
You mean practical advice, how to do it? Yeah. Well, as we know, thanks to Snowden, of course, there is no such thing as privacy. We are all being watched, and we can all be targeted. And there's no such thing as legal privilege either, or source protection privilege between the potential whistleblower and the journalist. So you have to take a risk assessment. What are you trying to disclose? So what sort of pushback, what players are going to be coming after you? And if you're coming out of intelligence, or even if you're coming out of government or big business with connections to that sort of world, the chances are you'll have at least a state-level player pursuing you. So that's when you have to start getting very, very paranoid indeed. And of course, there are very simple tricks. You can use a whole suite of different encryption and privacy tools, and that can include open source. It can include PGP encryption, Tor, Tails, OTR, all the rest of it, which I gather means off the record, but to me always means on the run, so I always get very confused with that one. So that's the tech side of it, of course, and you need to get an old laptop bought in cash or two, so you and your source can communicate securely with each other like that, and never use it for any other sort of communications. That, however, is just the sort of the tech side, and you then also need to think about the real world side around you. What are the laws that the whistleblower will be facing? What are the laws potentially you as the journalist might be facing? Because in the UK, for example, the journalist can face prosecution under the Official Secrets Act too. And then you need to think about the real world physicalities. So it's all very well having a nice secret computer or a burner phone to use, but if you have a conversation in a place that might be bugged, then at least one side of the conversation will be picked up and will tip off the authorities to the fact there's a whistleblower in the offing. So again, you need to think about the legalities. For example, in the UK, telephone intercept cannot be used as evidence against someone in court, but property bug intercept can be. It varies from country to country. The moment of vulnerability is when the source reaches out for the very first point of contact with you, because they will have to come to you somehow through a known address or a known telephone number, even if it's a mainstream office reception desk or something. So if you get that fateful phone call, you need to have some of these things in place, or be able to get them in place very quickly, and then start reading up on John le Carré to find out how to get to a hotel room securely, not be followed, pay in cash, all that sort of stuff. So I think I suppose just to conclude, people now are very aware in our fields of the technological surveillance and will try and take steps to avoid that. And of course, the tech community are developing tools, wonderful tools, to try and help journalists to do that. But they do tend to forget the legalities around what they're doing and also the real world physical security around what they're doing. And that's also what needs to be addressed. So it's a sort of holistic approach.
Second question.
Good morning. I'm a bit confused about putting on the same level the corruption and the whistleblowing. Yes, it is. I have to stand up, not the volume of my voice. Okay, so I perfectly understand that the corruption is one of the major problems in Italy. But I do not believe that we should talk about whistleblowing for the corruption, because it's a way of enforcing the idea that it's something exceptional that you have to say. I mean, it's something, the corruption is illegal, and everyone should just say it. The whistleblowing, I know it's not happening, but in my view, the whistleblowing is something different. It's something that relates to Ustica or to Bologna or to the names of the policemen that did what they did at the G8 in Genoa. It's not something that is related to an economic crime, but it's something that is related to strong, deep violation of human rights like torture. So that's why I think that talking about the corruption here is a way of forgetting the other problems that are more relating to the whistleblowing that is against the secret of the states, military and mainly military secrets of the states, as Manning and Snowden did. Thank you.
Yeah, okay. Well, on that, I do not agree entirely. I mean, I do agree that we shouldn't mix the two things. My point is that, well, for example, corruption cases, and we hear about that all the time, how would you call a public servant that discover corruption related to organized crime that is being allowed on the inside by high officials? I mean, the point is that there is no word for whistleblowing and there is no word for this kind of citizens. The protection, though, I think we're approaching like from a different point of view. I'm talking about this to put this issue, the issue of protecting these people who are denouncing from the inside. Because, I mean, we can hear about like cases like that in Italy all the time. Corruption cases, and we shouldn't just think about appropriation of money, but also, I don't know, organized crime, basically managing from the inside of public administration, the public tenders, for example. If I gave you the impression that I was mixing the two things, I apologize, that wasn't my intention, but it was a way to say protecting these people, people who are willing to come forward and denounce what's happening should be protected. We can think it should be protected by two different laws in different ways. That's up for discussion. There is nothing So a whistleblower protecting law would protect the people denouncing crimes happening in the public administration and people who want to denounce military action, like in the cases like the one you mentioned. Our speakers don't know, but it's like very important public cases where the government was involved in crimes, explosion, people dying, bombing. So, I mean, I do agree with you that there are two separate issues. My point from a human rights perspective is that protecting people that are part of the public administration, part of the agency, that are willing to come forward, it's an issue that we should treat, I mean, not equating the two, but with a law that protects these people. Perhaps maybe if we can find a word to define that, it would be easier. But it's also I think our responsibility as citizens to use that as a way to advance our awareness, to advance our awareness that we all have a part of duty and responsibility. We might not be in the position to denounce these things, but to share knowledge, to be more aware that there are many issues involved, and people who are willing to sacrifice themselves to come forward needs to be protected. And I mean, you might not agree, but I mean, the point is that we're approaching different. Whistleblowing is not the crime. Corruption is the crime. Government actions might be the crime. Whistleblowers are people who are doing such a thing. Perhaps we have different words in the future, and I hope that.
Can I just say very quickly, we have a slightly more evolved whistleblowing culture in the UK, and it is well recognized that people coming out of banking, the health sector, local government, finance, a whole range of different environments where corruption is exposed by people. They are commonly known as whistleblowers, and they face exactly the same stigmatization, loss of job, loss of income, loss of friends, loss of status, everything that the high-end intelligence whistleblowers will face. The only difference is they probably won't be prosecuted automatically and go to prison, but they are certainly deemed to be whistleblowers. And there are many hundreds, if not thousands, in the UK. And again, organizations coming together to try and protect them and fight their corner.
Can I just add just a point to this, just a bullet point underneath this? You know, we talk about whistleblowing in the context of government information, but I think that we would do ourselves a disservice not to mention that if you leak material about corporations, or if you're a journalist and you publish material about corporate malfeasance or make accusations against, you know, private companies, if we talk about whistleblowing, we have to incorporate that into our conversations, because you can be charged with libel, or you can be charged in the case of United States. I mean, watching how they're developing on the WikiLeaks investigation, you know, you could be charged with the Computer Fraud and Abuse Act, or with, you know, related sort of statutes. So I think we need to also expand our conversation. I mean, we live in an age where it's not just about surveillance. I mean, it's also an age of voyeurism. It's an age of spectacle where we're all on the internet and we're all want to be seen. So there's a nuance to this that needs to be incorporated. And when we talk about the Snowden leaks, we also need to talk about the role of private corporations in this paradigm as well.
Okay, and I think this is the best way to close our panel. Unfortunately, there is another one starting in a few minutes, so we have to stop here. But I guess all the speakers will be available to answer your questions outside of this room. And from my side, thanks a lot once more to this fantastic panelists here, and to all of you for coming us, and once more to CILD for getting it done. And to the festival, of course. And hope you enjoyed the rest of the day and tomorrow or so. And see you soon. Thanks.